So we have some major developments in the battle to end the NFA suppressor restrictions. This comes after the Trump DOJ shifted its position and admitted that suppressors are in fact protected arms under the Second Amendment. But despite that shift, the DOJ is still defending the NFA. But now this case has officially reached the Supreme Court. This petition directly asked the Supreme Court to decide whether the NFA's registration and taxation scheme for suppressors violates the Second Amendment. This case could have massive implications for suppressors and the regulation of those items, and also impact the entire NFA. So let's break down what is happening now in this critical case. Now, before we jump into this video, if you want to support the channel, one of the best ways to do that is simply to subscribe. You can also click the like button. That just tells the algorithm that you appreciate this content, and so it shares it to more people. I also want to thank one of the main supporters of this channel, which is 1st Phorm. You guys know that 1st Phorm's an amazing company. They support the Second Amendment and what we talk about here on the channel, but they also have great supplements. So if you're trying to get healthier, if you have a New Year's resolution, like me, I've lost about 20 pounds since the beginning of this year, and a lot of the supplements that I've been using come from 1st Phorm. So if you're interested, you can check them out using the link down below. If you order any supplements, you can get a free 5-pack of protein stick, and then also you'll be entered into a drawing to win some channel merch. So again, check them out using that link down below. So in this video, we're going to be talking about the US versus Peterson case, which challenges the constitutionality of the NFA as it applies to suppressors. This case has now reached the United States Supreme Court, and it asks for the court to review the NFA's restrictions on suppressors. Now, for those unfamiliar with this case started back in Louisiana, essentially back in 2022. In 2022, federal and state law enforcement officers executed warrants at Mr. Peterson's property in Louisiana. Among the items recovered at that location was a solvent trap that the government treated as a suppressor under the NFA. Mr. Peterson was charged with possession of an unregistered suppressor in violation of the NFA. Now, in response to that, he moved to dismiss the charge, arguing that the NFA's suppressor registration and taxation scheme does in fact violate the Second Amendment. But on review, the district court rejected that argument. That case then went all the way to the 5th Circuit, and at first, a 3-judge panel at the 5th Circuit level ruled that suppressors were not protected arms at all. But then something major happened in this case. The Trump DOJ decided to change its position, and they admitted that suppressors are in fact protected arms under the Second Amendment. So that was a critical shift that changed this case going forward. That then forced the 5th Circuit to withdraw its original opinion, but when the court issued a new ruling, it still upheld the NFA, but it just used a different theory. The 5th Circuit assumed that suppressors are protected arms by the Second Amendment, but it still upheld the NFA by saying that the suppressor system under the NFA works as a shall issue permit scheme. In other words, the court treated the NFA like a permit system. So under that logic, they said as long as the government processes the paperwork objectively and doesn't have discretion to deny applications, the restrictions could still be constitutional. So even though suppressors may be protected arms, the 5th Circuit said that the NFA survives the Bruin analysis. That ruling created a lot of issues and some controversy, because if that logic stands, it could justify many types of firearms restrictions on protected arms simply by labeling them as a licensing scheme. And that is exactly why this case is now heading to the Supreme Court, and it's asking for Supreme Court review. Today, Mr. Peterson's legal team officially filed their petition for writ of cert, asking for the Supreme Court to take this case. Now, the petition presents two major questions that the Supreme Court needs to address. First, can the NFA's taxation and registration system be treated like a licensing law or a licensing scheme? And second, does the NFA violate the Second Amendment as applied to suppressors? So in other words, the Supreme Court is being asked to decide whether the federal government can require registration and taxation of protected arms. Now, the petition's first major argument is that the 5th Circuit made a fundamental mistake in their ruling. It treated registration as if it was also a licensing scheme, but those are two very different things. Licensing systems typically verify that someone is a law-abiding citizen before allowing them to carry or possess firearms. Now, a registration, on the other hand, creates a database tracking who actually owns firearms. The petition argues that the Fifth Circuit improperly blurred those distinctions and kind of joined them together to say that both were the same thing. And by doing so, it allowed the government to avoid the historical tradition test, which is required by Bruin. So under Bruin, once the Second Amendment applies, the government must prove that a regulation is consistent with the historical tradition of firearms regulations. But the Fifth Circuit never even performed that type of historical analysis. Instead, it simply presumed that the NFA was constitutional because it looked like a licensing system. And the petition argues that this directly conflicts with what Bruin said. Now, the second major argument focuses on the NFA tax itself. When the NFA was enacted in 1934, the tax was regulating items like suppressors, and that tax was $200. At the time, that was roughly equivalent to about $4,800 today. So the petition argues that this tax was intentionally designed to discourage ownership of these items. And the Supreme Court has repeatedly ruled and focused on that the government cannot tax the exercise of constitutional rights. The petition compares this to cases involving the First Amendment taxes on speech, poll taxes on voting, and taxes targeting newspapers. So the argument is very simple in this case when it comes to the tax implication. If the Second Amendment is truly a fundamental right, the government cannot single it out for special taxation like the NFA does. Now, the third argument in the petition also points to the fact that there is no historical tradition of firearms regulations like this one in the United States. The founding generation did not require Americans to register their privately owned firearms with the government, and the petition argues that if the British Crown had attempted to impose this type of firearms registration and regulation before the American Revolution, it would have likely, sparked even bigger and more massive backlash. Under Bruin, the government must identify historical analogs to justify these modern gun regulations. But according to the petition, no such historical tradition exists for this type of firearms registration scheme like what is happening here with the NFA. The petition also warns that the Fifth Circuit's ruling was not clear and it did not have any limiting principles. Because if the NFA can survive simply by being labeled as a licensing scheme, the same logic could potentially apply to a broad number of restrictions. It could apply to other items like rifles, handguns, or other types of protected guns. In other words, the federal government could theoretically require registration and taxation of all firearms. That is why this case goes far beyond just suppressors and this single, defendant here, Mr. Peterson and his situation. It raises fundamental questions about the limits of federal gun regulation. So what happens now that the Supreme Court cert has been filed? Well, now that the cert petition has been filed, the case officially enters the Supreme Court process. The government will likely file a response trying to defend the Fifth Circuit's ruling and defend the NFA. Then the Supreme Court justices will decide whether they want to grant review. If the court takes the case, it could become one of the most significant Second Amendment rulings that we've got since Bruin, because the court would finally have to address whether the NFA itself is constitutional. So that's where this critical suppressor challenge currently stands. The Fifth Circuit upheld this restriction based on the NFA saying that it operated as a shall issue licensing scheme, which they believe is permissible under Bruin. Mr. Peterson has now asked for the Supreme Court to intervene, and now we will wait to see how does the Supreme Court want to address this case, or if other cases that are currently pending at the Supreme Court level or other cases that develop revolving around the NFA, if those will impact this case before the Supreme Court has any action on this issue. So as soon as we get more information on this, as soon as we get more development, I will let you guys know, but that's where this currently stands. If you like this video and you'd like to support the channel, one of the best ways to do that is simply to like, comment, and subscribe. All of those things help to fuel the algorithm and just tells the algorithm that you appreciate this type of 2A content, and so it shares it to more people. But as always, thank you so much for all of your support, and never forget this nation was built by armed scholars, and this nation will be maintained by armed scholars.